sake of preserving the anonymity, we would request that the parties either use HG or continue to some sort of anonymous descriptor, if you could please. With that, I will call the first case, 127-548, 127-573, Sparks versus the estate of Clifford Sparks. If the parties could please come forward and announce their appearances.
Your Honor, David Lockett for the appellees and claimants.
Thank you. You may begin. I would ask that appellant, if you could provide a brief, like 1 minute factual recitation that just kind of explains how we got here, because we are live streaming these cases. So for those who obviously have not been immersed in this litigation, that they could have some understanding of how it is we got here, and that will not count against your 15 minutes of time. Would you like rebuttal time?
Yes, Your Honor.
How much?
I'll take 3 minutes.
3? Okay. Okay, let me proceed.
Thank you, and may it please the court. To start with the requested factual summary here. Going from the beginning, there was a marriage between we'll refer to him as Senior to avoid mixing up the children's names, Clifford Sparks Senior. Married Juanita and had 3 biological children with Juanita. At the time of Juanita's death, the Senior and Juanita owned a substantial amount of property as tenants in common. Following her death, the property was to be given to their 3 sons, divided equally. Juanita's property, that is. At the time of the death or after the death, the 3 sons and Senior entered into a family services or family settlement agreement in which the 3 sons agreed to waive their rights in Juanita's property in favor of their father, Senior. Plaintiff alleges that at the time the FSA was entered into, that there was an oral promise from Senior to the 3 sons, stating that Senior would divide the property 3 ways upon Senior's death. As we fast forward years later, there were several transactions, dispositions, divisions of the property that made up Juanita's estate. Several years later, I believe in 2018, Senior went ahead and actually created a new trust, an amended trust. As part of that amended trust, Senior divided his property specifically to 1 son, Gary, and left the other 2 sons with $50,000 of a distribution. Plaintiffs have brought the underlying action alleging that Senior, among other things, Senior committed constructive fraud by not following through on his oral promise roughly 30 years ago. They also filed claims for unjust enrichment, and a few other claims which are not actually dealt with here today on this appeal. So the underlying issue that we have today is that this is a case in which the trial court found in favor of plaintiff 2 sons of Clifford Sparks Sr. for constructive fraud based only on a single uncorroborated statement allegedly made by Clifford Sparks Sr. over 30 years before the trial reached its conclusion. In reaching this conclusion, the trial court committed 3 plain errors. First, it erred in concluding that Clifford Sparks Sr. committed constructive fraud. Second, it erred by summarily overruling defendants' affirmative defenses in plaintiff's favor. And third, it erred in denying defendants' alternative motion to add findings of fact in favor of support of the judgment. Plaintiffs on cross appeal alleged that the trial court further erred by 1, limiting the scope of constructive trust, and 2, finding in favor of defendants on plaintiff's unjust enrichment claim. These points on cross appeal will be addressed in turn. First, during the point 1, the district court's finding in favor of plaintiff on plaintiff's constructive fraud claim was an error because the finding was unsupported by substantial competent evidence. To be entitled to a constructive trust, plaintiffs were required to prove that their constructive fraud claim by clear and convincing evidence. To succeed on this claim, plaintiffs were further required to prove Senior breached a legal or equitable duty. A constructive trust claim also required the plaintiffs prove 1, the existence of a confidential relationship, and 2, a betrayal of this confidence or breach of duty imposed by the relationship. In this case, plaintiffs failed to provide clear and convincing evidence either that Senior breached a legal or equitable duty or that there was a confidential relationship that existed.
Tell me, didn't the trial court find that the father, Senior, made an agreement with his 3 boys orally that if they gave up their interest in their mother's estate, he would treat them equally upon the distribution of his estate?
Yes, Your Honor, that was a finding the trial court made. Our argument today is that that finding was not supported by the evidence in the record.
So you're saying there's not substantial confidence?
Yes, correct, Your Honor.
So but the court made that finding, and it's the one that makes the determination of credibility, right?
That's correct.
So if the court made a finding that dad would give them a third of his estate if they gave up their mother's estate, why isn't there an imposition of the entire estate goes a third, a third, a third?
Your Honor, if we look at the actual facts that supported that finding, the facts that we have based on plaintiff's side are simply two uncorroborated statements from the plaintiffs themselves that this promise existed. The third brother, the defendant, has never testified that that promise existed.
Well, no, he got 100% of it.
Correct.
So it's counterintuitive for him to testify in conjunction with his brothers, isn't it?
That is correct, Your Honor.
So tell me, if that was the finding of the court, that there was a promise, then how do we change that finding? And what impact, if we leave that finding alone, what impact does that have on the distribution of this estate?
Your Honor, if we look at the actual facts of the case as they're presented, especially in the trial court's final judgment, there is not substantial evidence to prove the existence of the alleged promise. If we look at the factual situation when the promise was made, we have the FSA itself, which was entered into about the exact same time as the promise, which explicitly waived plaintiffs' rights in the property, which they allegedly were conveyed by the oral promise. The FSA even says that they read and understood all of the terms of the FSA.
You talk about the FSA when the mother passed away, after the mother died?
Yes, Your Honor. The alleged oral promise happened almost around the exact same time as the FSA was executed. In fact, plaintiffs have alleged that the oral promise was part of what caused them to sign the FSA.
So why wouldn't that have been included in the FSA?
Your Honor, it wasn't included in the FSA because we don't believe the promise ever existed. If we look at the explicit terms of the FSA, plaintiffs waived their entire right to Juanita's estate. And they further affirmed that when they executed it, they had read and understood all of the terms of the FSA. That FSA was put before a district court and entered into in the legal record. So we have a court case, we have an FSA, all of which say that this oral promise never existed and never included this alleged oral promise in the actual terms.
Counsel, you make some valid point, but that's in a vacuum. We have sons who've inherited this estate from their mother, and they give it to their father. You can't excuse the unique facts of this case of the trust that is built in. They didn't even show up at the hearing when this was processed with the father and his attorney. Isn't that, I mean, all these little factors, I say little, but that's not true, factors of these are sons giving their property to their father. So that trust that is built in to a parent, they said they never read the agreement. Shouldn't that be considered part of the substantial competent evidence? Because if you're offered a later date, a burden, if you're offered a later estate, much bigger, wouldn't you trust that person that would happen? So how do we get around the fact that this is a father's statement to his sons and the trust that sons have?
Your Honor, I understand that there is an inherent trust between a father and son. I understand that fact. But if we look at the actual judgment and what was found by the trial court, they didn't find that created a confidential relationship. They didn't make any finding as to the confidential relationship. And what we're saying now is that there is not substantial competent evidence that such a confidential relationship existed. We have Kansas case law that says a confidential relationship cannot be formed merely by the relationship between a father and son.
But that wasn't the case here. And I get that. And I totally agree with you, but that's not what we have here. And there is also case law that says if you have an agreement on top of that relationship, then there is a confidential relationship. So if we have that agreement on top of the father-son relationship, how is that confidential relationship piece not satisfied? And I guess what you're going to tell me is because we don't believe that agreement existed.
Your Honor, we don't believe the agreement existed. Again, we have this alleged oral promise at the time of the FSA's execution. The FSA does not incorporate those terms.
But then the FSA is inexplicable. Otherwise, why would they relinquish the property?
Your Honor, I can't speculate as to why they would do it. I know at the time, Senior had expressed an interest in just simply keeping the property together. That was his life's work. That was what he was dedicated to doing. There's nothing to say that the two sons at the time of the execution of the FSA didn't do it simply out of the love of their father.
So isn't it equally on the other side, if because it's circumstantial, both of these are, isn't it equally true, or couldn't it be equally true that there was an agreement? That it just as though they may have done it because they love dad, they may have also done it because there is this agreement.
Your Honor, there is, in our opinion, substantially more evidence pointing toward the fact that no agreement ever existed. Setting aside even the FS, sorry, Your Honor, if you wanted to.
No, go ahead.
Could you remind me how much property they relinquished back to their father in 1993? What was the acreage? What are we talking about? Could you remind me, please?
Your Honor, I would have to go back to the record and look. I don't have it off the top of my head. It was what they actually relinquished in 1993 was their interest in Juanita's estate, not in Senior and Juanita's estate.
Correct.
That has since been muddied significantly by the time we reach here today.
Right. So, but you couldn't tell me what the acreage is back in the property size back in 1993 from Juanita's estate.
I don't recall the property size exactly, no, Your Honor.
But it was basically, if we're going to break it down, so it was divided in halves, half to the boys, half to dad, and then further divided, they each got a third of that half or sixth or whatever.
That's correct. But as I was saying a minute ago, if we look at kind of the evidence that was existing at the time, well, not even at the time, if we look at the existence even post the FSA, Senior went to an estate attorney later on, Senior went to a financial planner later on, and both of them, he never mentioned the existence of this purported oral promise. He only mentioned that he wanted to keep his estate together because it was his legacy, that he didn't like the two plaintiffs as his sons, and that he wanted them to inherit nothing. And he continued to say that throughout the entire process of creating his new trust, the amended trust, and to his financial planner before his death.
And so didn't he accomplish that by getting them to relinquish it to him under the nefarious reasoning?
They had relinquished their interest in Juanita's estate. That's correct, but he did not want his sons through intested probate to inherit any part of his estate on his death.
Well, quite frankly, I don't think he wanted either of them to get anything. And so by getting them based on the record and his feelings towards his sons and what was expressed throughout, that he really didn't want them to have anything. So doesn't that also support the fact that he encouraged them to relinquish this property based on these false promises? And so then that would allow them to not receive anything as he intended?
Your Honor, there's also a substantial amount of evidence, as plaintiffs will even admit, that Senior was an extremely honest man whose word was his bond. It's hard to believe that if he had such a bond, that he would go around telling his own financial planner, his own estate attorney, that no such promise existed when he knew, in fact, that it did. In fact, that would tend to show that no such promise ever existed until plaintiffs decided that it happened 30 years after.
Doesn't that go back to the initial question that I asked, though? There may not be any written agreement because he is so honest, because he is his father. There's an understanding that they will be able to remind him every time they see him, et cetera. So doesn't that actually go to the other argument as well? The fact of his honesty, they did not need. I mean, this is the kind of person who did things by a handshake, right?
Yes.
So a handshake is the same as a written agreement, and therefore you may not even find one.
Your Honor, that is correct, except when you subsequently enter into a written agreement that does not contain those terms. What plaintiffs are introducing is nothing more than parole evidence at this point of a purported oral agreement, which was never actually codified in the agreement that they came to. The agreement, which was then admitted that the plaintiffs read through, specifically waived their interest in that property, and was then entered by a court.
Let's see, do it on time.
He's got another minute and a half.
You have another minute and a half. Can we move to the last issue?
Yes.
Because I know you're going to want to also, but that way you can discuss it on rebuttal too.
Your Honor, for clarity, do we want point 3 or
the plaintiff's unjust enrichment claim? What is your argument? I know you're saying that the court shouldn't have done this if it did. What is your argument that they should only receive, and I know you're advocating for your client, property split from 1993 versus present day 2018. What's your argument?
Yes, Your Honor. So if we look at the actual law of an equitable trust, it's an equitable result. So what we're looking at is the court looked back to when the actual unjust act occurred. The unjust act occurred when Senior allegedly, I mean, we're going to have to couch that throughout this entire argument here.
That's why I phrased that question that way, so your client doesn't get upset.
When Senior allegedly committed the fraud or perpetuated this false oral promise, the false oral promise caused them to waive Juanita's estate. It did not specifically cause them to do anything else. That's what the district court found, was that that was almost a fraudulent inducement, more so than a broken promise. So by the district court's characterization of the events, Senior fraudulently induced the two plaintiffs into waiving their rights through the FSA. That would, through an equitable trust, entitle them to whatever they waived, which was Juanita's half of the estate, not Senior's full estate.
But it does entitle them to any appreciation, right, of Juanita's estate over time.
Yes, Your Honor, that would be something we'll have to figure out how to
Right,
do.
and I know
in
the
subsequent
district
years.
court had said if we're going to do this, then we have to have a better accounting of exactly where we are. But it wouldn't be given to them, or their portion of the pie would not be as it existed in 93. It would be that and however it has appreciated or improved.
Yes, it'd be whatever existed in 93 plus interest, however we want to calculate that, yes.
So the tracts of land that they owned, some of them were 40-acre tracts, some were 80-acre tracts. Were they all still owned by Senior at the time of his death?
No, they've subsequently been divided, they've been sold, there's been new property purchased. We would have to go through and do a full accounting of what's actually existing at this time.
So Senior used it to his benefit.
Correct.
You are into your rebuttal time, but because of your questioning or our questioning to you, we will give you that grace when you return.
Right. Thank you, Your Honor.
May it please the court. I would like to reserve 3 minutes for.
You don't actually get rebuttal time.
Okay.
You're all and done.
Let's pack up and go.
Yes.
Well, I would like to concentrate, because we only have 15 minutes here. I'd like to concentrate on the unjust enrichment claim, but I will respond to some of the issues that the court questioned opposing counsel on, because I think it's incredibly relevant.
Can I start you at one point that's confusing for me?
Yes.
Okay, so we have a constructive trust or constructive fraud, but the court did not find unjust enrichment. So my understanding is that it's an equitable remedy to right a wrong. But if the wrong was found to not exist, what are we righting?
That raises a number of different issues, Judge. So if I can work through them. Unjust enrichment and constructive fraud are related. Constructive fraud is a subset of unjust enrichment. So we have a unique situation here where the judge said there was a constructive fraud. By very definition, that is a form of unjust enrichment. But at the very same time, the judge said, for the reasons we'll get into later, that there was actually no unjust enrichment. So it's entirely inconsistent. There's two leading cases in this case, and I believe the court can resolve this case by the four corners of Draper and Nelson, which are the court, both parties have been referencing throughout. So it's a unique situation. We have a fraud and we have no unjust enrichment. The court erred with regard to the unjust enrichment claim because it's a 3-element claim, and the court added privity as the 4th element. There's no citation in the legal record. I have yet to see a case that says that is the case in this case. So it's kind of unique. And I would argue to the court that the elements of the constructive fraud, the court's findings of fact, establish all of the 3 elements of unjust enrichment. And as the court is aware, it requires conferring a benefit, retention of the benefit, and that it is unjust. It's unjust as a matter of fact because the transfer into the trust was procured by a fraud and it was fraudulent. It's also unjust and unlawful as a matter of law based on the holding and the syllabus in Nelson and Draper. Those two companion cases came down the same day. The Supreme Court spent considerable time addressing it worked backwards. It said, when is somebody entitled to a constructive trust? What claims give rise to the constructive trust? And they analyzed unjust enrichment, constructive fraud. And then they went back and said, well, the elements of these two claims. So in my mind, the case is kind of backwards. You start at the remedy and go backwards rather than the elements. So I had a bit of a problem with that. But if you review the syllabus in Draper and Nelson, they're the same. The court says, and this is the dispositive issue regarding unjust enrichment in this case. In paragraph, in both of the syllabuses, the court says, where the owner of property transfers it in fraud of third persons, the transferee holds this property subject to their claims unless the transferee is a bona fide purchaser. It's exactly what we have before us today.
So what remedy are you requesting of us today?
From the get-go, from the time we filed suit, we did so in reliance on Nelson and Draper. And we elected our remedy, which is the enforcement of the promise that was made to the three sons. We established liability for constructive fraud. The court gave us the constructive trust that we asked for, and it was limited. And if I take a moment, mathematically, we were asking for a third of the estate.
Total, the senior's total estate.
Absolutely. Given the history of the case, the judge returned what my clients gave decedent a long time ago. And mathematically, if all the property remained in the estate and he just carried on, mathematically, they gave a 12th of the estate in 1993. They were promised a third of the estate in 2019, and the judge granted them a constructive trust to get the third back. That's nearly 30 years has allowed.
Third of the original of their mother's estate.
Their interest arose out of intestate succession. So
they would have gotten each a sixth of their mother's half.
That is correct.
All right.
So that's a 12.
Or gave them back.
Right.
Which would be 1/12 of the whole estate.
Assuming, and it's a big assumption, assuming all the property stayed in the estate and there were no changes. Unfortunately, there were a lot of changes, and basically it's going to need a whole new trial to figure out what our clients are entitled to. But we shouldn't get to that point because the court made reversible error when it allowed the trust to take a part of the third that was fraudulently transferred to the trust.
But isn't the way that the court awarded it in alignment with case law? Aren't they only entitled to what was taken from them? And at the time the promise was made, the only property they actually had a right to was their piece of Juanita's estate.
Yeah, Judge, I have no idea where that came from. The word taken is in either Nelson or Draper. You're allowed to recover what was taken from you. In this case, what was taken from them was a promise. We elected our remedy that was to recover the property that was taken from them, which was a promise of a third.
So when we talk taken, your position is it's a question of timing as to when that taking occurred. Because when they entered into the promise, all that was taken from them, all they had to give was what they had in Juanita's estate. So you're saying that when we look at taken from when senior passed, because then what was taken from them was what they would have been entitled to under this promise?
That's consistent with the case law, Draper and Nelson.
That timing is...
And I would argue that nothing was taken from them in 1999. They voluntarily gave a 12th of their mother's estate in exchange for a third in the future.
Wait, a sixth of their mother's estate.
Oh, sorry, a 12th.
It's a 12th of the whole estate.
Correct.
I just want to make sure we're on the same.
Yeah, I'm sorry for the confusion. I see the farm as one kind of entity, and mother owned 50%. So we got a sixth of mother's estate, not a third of the entire estate.
Does the fact that we are now looking at this 30 years back change our reasoning at all?
Not at all, Judge. That was the district court's job to figure out what happened, and it did. we talked, opposing counsel argued a little bit about the substantial competent evidence. It was real simple. We had two witnesses who both stood up and said the promise was made. That but for the promise, they never would have given their own father real estate. And there was no testimony that was inconsistent with the testimony. So the court had no evidence that was contrary to my client's testimony. In fact, Mr. Gary Sparks stood up and said he had no recollection. So the only abuse of discretion here would be if he didn't find that the promise was made to my clients. That's beyond reproach, and the court should affirm the judgment on those grounds alone.
So you're saying, counter to your opponent, that there was substantial competent evidence that Senior was a man of his word.
Yeah, we cited throughout the appellate brief everything, right? So it was unique in so much as we had a lot of exhibits, but ultimately people take the stand and they testify. My clients both took the stand. Gary took the stand and said, gee whiz, he didn't recall what happened in 99, which is perhaps not surprising. But there were also other witnesses, family members. There was one of my client's daughters is estranged from him. She did not want to testify. I would consider it to be a neutral third party. And she testified that she really did not want to support her father, but she desperately wanted to support her grandfather. And she said he, throughout his entire lifetime and even after his death, his intent was to make sure each of the three sons took a third each.
But then how do we square that with the statements of clear animosity to the financial advisor that he does not want them to receive anything? So at what time is he a man of his word then?
Well,
or when it favors them?
There were two separate, there were a number of different attorneys representing his creation of a probate estate. There were multiple. He kept on moving from one to the other. I'm not going to say what the timing was, but the second to last attorney showed up at trial and testified and said, before he died, he expected the decedent expected each of his sons to take a third, a third, a third. So, as far as the timing is concerned, mother died in 99. We have testimony, and the judge found that the promise was made. Maybe, and I want to be a little bit woolly here, maybe two or 3 years before he died, he met with the second to last attorney he met with. And at that, Mr. Ramsdale testified before the court and said, at that time, he still wanted to treat his sons equally. So I think something happened in the last 12 months, perhaps, of his life. And we also claimed undue influence claim that was rejected. It's not on appeal right now. If that was the only claim, would appeal that, but that's not before us today. But there was significant evidence that things changed 12 months before he died. But we can resolve this case by doing three things. One, affirming the liability for constructive fraud, as we stated in our brief, providing our clients with the remedy dictated by Kansas law, which is the enforcement of the promise.
And you believe that Nelson and Draper supports that position?
Absolutely. Not only does it support the position, both the cases expressly state, and I'll read directly from the case, where the owner of property transfers it in fraud of third persons, the transferee holds the property subject to their claims unless the transferee is a bona fide purchaser. What that means in this case is the owner of the property is decedent. When he transferred it in fraud of my clients, which is established by the trial court, the transferee, in this case, the trust, must hold it subject to our claims for an entire third of that property. So it's not like a discretionary, woolly, nebulous concept here. Draper and Nelson both say that when there's a fraud, the transferee who takes through that fraud cannot take title over my two clients.
What is the size of the estate today in comparison to what it was in 1990?
I would have to speculate. I suspect it's 20-30% bigger. But a lot of these questions, Judge, come about because both sides and the judge talked about the family as a whole and percentages. So there's no record on the value. There's no record on.
Well, I mean, I'm assuming there was an inventory and valuation filed in senior's estate.
I assume so too, Judge.
You've not seen it.
I have not been. No, his will was a pour-over will, but everything went into the trust.
Okay.
Whether it was an inventory, I have not. I have not
Okay,
reviewed it.
okay, you haven't seen the trust assets.
Have we? No, we have had no accounting of anything that's happened in the trust since 1999, which is a
No, wait.
intention.
No, the trust didn't go into effect until he passed away, right?
Correct. Sorry, I said 99, 2019. 19 on his death.
All right.
Yeah, there's been no accounting at any time since that time. So we're dealing with real estate money and percentages.
Counsel, you said you had three things, and I was writing them down. Liability for the constructive fraud, your remedy. What was the third?
The third one is, we've kind of touched on it briefly, unjust enrichment.
Okay.
Okay, so we discussed it previously. Unjust enrichment is nothing, constructive fraud is a subset of unjust enrichment.
Right.
The court said there was a constructive fraud and there was no unjust enrichment, which is kind of curious. But regardless, the reason for that was the court found that our clients must establish privity. There's no case law to support that. Draper and Nelson, if we go back to the two documents, four corners of Draper and Nelson, they tell the court exactly what the elements are. And it was listed in the pretrial. The elements are, well, we know, conferring benefit retention and that the retention is unjust. As we are stated earlier, it's unjust because a promise was made. It's kind of axiomatic, but it's also unlawful given the holding that I've referenced a couple of times in Draper and Nelson. The transfer to the trust was fraudulent. According to Draper and Nelson, the trust cannot retain $1 of that fraudulently transferred property.
Counsel, I'm going to throw a hypothetical out to you, which is nice of me because usually you don't get that topic sentence. It's 1993. The sons enter an agreement with their father. Okay, they don't go to the hearing, and they are told that promise. Let's assume that promise was correct, that they will receive 1/3 of father's estate. My question really focuses on what they receive back. Suppose 10 years later, they find out father had no intention of dividing his estate in 1/3. They find out this because he's selling off all the property and he's keeping the money. And so they go to court. Would the remedy be you get back your property from that 1/3, or the remedy would be you get 1/3 of father's estate at that time? You see what I've done? I've basically moved the I've moved the point to get you that field goal. So go ahead.
Right, Judge, a deal's a deal. They were promised 1/3. Case law, either Draper or Nelson or both, says that the promise, when it's proven, creates a life estate. So he would have a life estate for all of the farm property.
So if he was still alive, the district court judge should have said you get 1/3 of your father's property. And father, you have to follow through with your promise.
Absolutely. Right. But we didn't get to that hypothetical because the second he died, there was a set amount of property. We didn't ask for anything that has left the estate. We asked for what was no more than what was provided to us in the promise. But case law does suggest that, or Nelson and Draper do suggest that the promise to transfer real estate on your death essentially creates a life estate. So we had a life estate. At what point would distributing assets become unconscionable or subject to a claim? That's not before us here today, because we're asking for a third of the end result and no less.
So what do we do with the fact that David accepted the $50,000 distribution?
There's no evidence before the court. He did. There's no evidence before the court that he waived anything by accepting the distribution. It's a partial payment on his third.
And then my final question.
So you're saying there's no evidence that he took that he accepted the 50,000?
He accepted the 50,000, Your Honor. There's no evidence that he waived anything in accepting that payment.
There was no agreement.
There was no agreement provided to the trial court.
There was no condition upon accepting that 50,000. That I thought it said if I accept this 50,000 that I waive any kind of claim or fussing over the trust.
The exhibit was never introduced to the trial court.
So it's not evidence.
It's not before the court. And I would say we could argue the merits of what was in there, but we didn't have to. It was both the parties and the court stipulated the introduction of the exhibits, the distribution that the court is agreement that the court is referring to was never submitted to the court.
So they stipulated that he accepted it, but they didn't take the next step of then admitting the exhibit.
That's correct. And there's no stipulations regarding the legal effect of whatever agreement there was. In a nutshell, we could have tried the case and fought over the legal implications of whatever distribution agreement there was. We never had to because it was never in evidence.
So it was
disputed.
So what did the judge know? I just want to make sure we're very clear on what is before us in terms of the record. The judge knows that the second son, the stipulation that he accepts $50,000, correct? Is that all the judge knows?
In the pretrial order, yes.
In the pretrial order, does the judge know about the condition that is based upon?
It only exists in the distribution agreement that was never admitted.
Never admitted. Anything in the stipulation at all?
No, the pretrial order from memory says that he accepted 50,000 and no more.
And then it's just blank. It doesn't have a condition. You can't contest.
so just hard stop. He took this 50,000 and we're all happy to just leave it there.
Who knows how or why it happened, because the evidence was never introduced to the court.
So and this is kind of going back to my original question to you about the unjust enrichment, because in Nelson, it says on page 579 that the constructive trust is a remedy for unjust enrichment. And that this is the view that's widely and uniformly accepted. So I guess I'm having a mental battle with that finding by our Supreme Court and your assertion to me that basically those are just two pieces of the same basket, that a constructive trust and unjust enrichment are just two of the same animal, but that doesn't seem to be what the Supreme Court is saying. They seem to be saying that the trust is a remedy for unjust enrichment. And that's where I'm getting confused because the court here found no unjust enrichment. So if you could quickly untangle.
Well, yes, Judge. Again, the cases kind of move backwards from what is a trust, when do you get it, what are the claims that lead to that trust, and what are the elements of those claims. Kind of, I struggle to wrap my head around it because it's backwards. Beyond a shadow of doubt, if Draper and Nelson stand for any proposition, is that constructive trust is no more than a remedy. It's a remedy for unjust enrichment. Constructive fraud is a subset of unjust enrichment. So unjust enrichment can be proved many different ways. In our case, it was proven by the fraud, and to a certain extent, the court's findings of fact establish the elements of constructive fraud, establish the elements of unjust enrichment. In reality, you cannot have one without the other. Decedent defrauded my clients when he transferred the property into the trust. The trust was unjustly enriched when it took the property that belonged to my clients. And it's not just a kind of an equitable issue, it's a legal issue. Because Draper and Nelson say that fraudulently transferred property cannot be retained by the trust. So the elements are all there, and the only fly in the ointment is the judge found that privity was required, and Nelson and Draper went to considerable lengths to summarize Kansas law on constructive trusts, unjust enrichment, and they found that privity was never an issue. It's not an element of the claim. And it was for the pretrial order included the parties and the court's understanding of what was going to be tried at trial. And in the pretrial order, we tried the case on the pretrial order. The pretrial order said there are 3 elements to unjust enrichment, and Mr. Lockett and his clients have to prove it. So we were kind of blindsided. And to this day, I'm not entirely sure where the privity element comes from. I've not seen case law regarding intervenors promise cases that can support that conclusion. So quite frankly, to sustain that requirement, we're going to have to overturn Draper and Nelson. The 3-element test would have to become a 4-element test. And again, the court spent considerable time and effort providing everybody in the state of Kansas with an outline of what needs to happen in these cases. And they provided it in the syllabus. And from the get-go, we followed that syllabus in questioning our claims and requesting our remedy.
I know we're going over time. I get that. But it adhered, it being the court, adhered to all the elements plus privity, right? So does it matter?
Well, it absolutely does. It's an equitable claim, Judge, but if we're looking at the equities, I mean, I guess a judge could come up with whatever elements, but he didn't say it was an equitable consideration. He said it was an element of the claim.
But how does that adversely affect your position? Because if it found all the other elements, then this was just an extra and it was an error, unless I'm not understanding the record correctly.
Well, it's a big extra, Judge. Using that hypo, we've met the 3 elements, we've followed the pretrial order, we've introduced all the evidence that we need to prevail, and then the judge says, oh, by the way, there's a new element. It doesn't exist in Nelson and Draper, and it's called privity, and you didn't prove it.
So your position is that somehow by including privity, that impacted the remedy that the court found was available?
No, unjust enrichment was rejected because we didn't prove the privity element. Under unjust enrichment, we lost that claim, so we're not entitled to a constructive trust to remedy unjust enrichment. Separate from that is the constructive fraud claim. We proved it. That established the right to a constructive trust. And as we've discussed, it gave partial relief that is contrary to Kansas law. So if we work down, the constructive trust could be issued for either of our 2 main claims.
Right. And so you got the constructive trust. So then why does it matter?
It matters, honestly, unjust enrichment matters a whole bunch in my mind. It's a very easy decision for the court to make. There's 3 elements. The judge said there was 4. There are no affirmative defenses pled to unjust enrichment. So we don't have to go anywhere near any of the affirmative defenses. And it appears to me the elements, if we resolve the privity issue, the elements are all met by the court's finding of fact. We also don't have to address what the remedy is for unjust enrichment. We don't get into the discussion of whether it's a 12th of Juanita's 99 property or a third of the property today. Because again, if Draper and Nelson stand for any proposition, is the remedy for unjust enrichment is the enforcement of the promise made. So it's a one-stop shop. If we wave a magic wand and overrule the court's requirement of privity, my clients will recover everything they are entitled to.
So it goes back to what I said, that privity, that your position is this privity piece that shouldn't be there directly impacts the remedy that they're entitled to.
Correct. That was a long way of agreeing with you, Judge.
Hey, it was a long walk, but we got there, right?
So and put it in very, very simple terms, and I appreciate your patience with us. This is a contract between two people. He was able to get land from them, and he was unjustly enriched for 30 years. Therefore, their remedy is what he promised them. We don't have to go back to 1993, promise of a third of the half mother's estate. And
Absolutely.
that's why
Mhm.
you're so adamant, and we need to make sure we get this issue correct because it changes how it changes the remedy.
Yeah, Judge, let me give you the court a hypothetical. Let's say my clients gave
I'm
nothing.
going to interrupt you. That's really not good for the audience to see that we're accepting hypotheticals, but I'll let you do it.
Let me change the facts. Let's, for the sake of argument, say that no consideration. There was, in 1999, a promise was made.
Right.
Our clients, maybe the only thing they did was not invest in retirement. Okay? That doesn't change anything here. The fact that they gave something in consideration for the promise is of no consequence. If we look, the best example I can think of is
They gave consideration for the promise here.
absolutely,
Okay.
absolutely, Judge, and establishes detrimental reliance, but it's not required. So I don't recall whether it's Draper or Nelson. One of the cases involved a trust that gave money to the American Heart Association, the American Cancer Fund. Well, clearly, that entity did not give anything in consideration for the bequest. It gave $0.00. It was a completely gratuitous transaction. And they could enforce the promise. And anyone can. So consideration is neither here nor there. The issue is what was promised and what did the decedent own on the date of his death.
But we have the additional fact that there was consideration.
That exists in this case, Judge.
Right.
But in my mind, it's like, you know, I promised to pay my mortgage. I'll pay it for 30 years. I don't get to change my mind and say, you know what, you can have the house back. It's just that's it in a nutshell. A deal's a deal. These are family members. These kind of family agreements should be upheld by the court because it's unjust. And apart from that, it's unlawful for the trust to keep anything. I keep on belaboring that point. But the plain language of Draper and Nelson says when there's a fraud, the transferee does not get to keep it. So following that logic, the trust has to disgorge 2/3 of the property back to my clients because to do anything else is completely unlawful.
Any further questions?
Thank you.
We'll release you. We will give you 2 minutes of extra time on rebuttal. We'll give you 5 to allow for some of the extra questioning. If there is something that we discussed with opposing counsel that you would like to touch on.
Yep. Thank you, Your Honor.
Yes.
I would actually like to start by going back through our second point, which was the court's denial of our affirmative defenses. The trial court entered a one-sentence finding that simply said our affirmative defenses fail. There were no specific findings of fact or conclusions of law about the affirmative defenses. There's no discussion of waiver. There's no discussion of res judicata. There's no discussion of the statute of frauds. But if we look through what was actually presented to the court, there is substantial evidence that plaintiffs did waive their claims that they bring here today. If we look at the explicit terms of the FSA, they're clear, and then they must be determined without consideration of parole evidence, such as purported oral promises. The FSA is, in fact, a valid family settlement agreement. It's a written document, both parties signed, and it was entered by the court. It explicitly waives plaintiffs' claims in 1/3 in their interest in Juanita's estate. They signed a form that said that they understood the terms. It was entered by the court as such. The existence of a purported oral promise is nothing more than parole evidence. And if we even look at Kansas case law, Plaintiff's attempt to craft a promise out of this purported oral promise is far afield of what Kansas has actually found, even when it did uphold oral promises. As we cited in the Camp Schroeder case in our response, Camp Schroeder concerned a recorded conversation, not an uncorroborated statement. There was an actual piece of evidence that said, here are the exact terms of this alleged oral promise. If you look at In Re Profit, there was a husband and spouse who discussed their assets over nearly a decade with each other. There was testimony to that fact, and they actually had conversations with third-party individuals that corroborated those conversations that the husband and wife had together. If you look at the facts here, there's this purported oral promise over 30 years ago between apparently only Senior and the two plaintiffs, not between the defendant's son.
Now, wait a second. We understood earlier the plaintiff's son had no recollection.
That is correct. There is, I will rephrase, there is no recollection.
Not that he didn't hear the agreement, he just had no recollection.
You're correct. I will rephrase, Your Honor. The third son does not recall that conversation or that promise ever existing. I was imprecise with the wording on that. I apologize. But that being said, so we look at supposedly Senior's word was his bond. He then goes to his estate attorney when he amends his trust and never mentions an alleged oral promise. He actually says he wants to basically disinherit two of his sons, give them $50,000, let them go on their way. He then goes to his financial planner only about a year before his death and says the same thing. He wants his estate to stay together. He wants it to be intact upon his death. And he wants it to continue being his legacy, that family farm.
But then how do we square that with the testimony from counsel that opposing counsel referenced that he did want to ensure that they each received a third of his entire estate?
Your Honor, I think there is a timeline that exists within this factual scenario where at some time during Senior's life, he wanted all of his sons to inherit 1/3 of the property. That is entirely squared with the defendant and to some degree the plaintiff's recollection of events at this point.
So, I'm sorry, go ahead.
But clearly, there is no corroborating evidence other than plaintiff's own testimony brought forth 30 years later that this purported oral promise exists.
So the testimony at trial from one of Senior's attorneys that he did want the three of them to inherit equally, you're saying occurred somewhere in the timeline that preceded the statements to his financial planner or whomever that he didn't want them to obtain anything or receive anything.
That was his second to last estate planning attorney. That was who created the original trust. When he made the amended trust, he actually changed it to disinherit the two plaintiffs. Well, he gave them 50.
And he had several trusts along the way, correct?
That is correct.
And up until the last one, all sons received equally a third of the estate. Is that correct?
That's correct.
And so for 29 years, all sons received a third of the estate.
Correct.
Thank you.
Moving to our second point on the affirmative defenses, we touched on it briefly, but this son, David, did actually accept the $50,000 that was in the 2018 amended trust and waive his present claims anyway.
But that waiver is not in the record, is what your opposing counsel said.
Your Honor, he's correct that the distribution agreement is not in the record. There is testimony and there is a stipulation that he accepted the $50,000, and there is testimony from the estate attorney that that $50,000 was for a waiver of claims. It was to prevent a lawsuit.
So the court was aware that there was a waiver of claims.
Correct, Your Honor. Moving on to our next affirmative defense, defendants made an argument that res judicata should have barred plaintiff's claims. As we've discussed already, the FSA was in fact entered by a district court in the state of Kansas. We understand that plaintiffs chose not to appear for that hearing. However, plaintiffs had a chance, if they wanted to appear for that hearing and say, hey, Your Honor, I don't see this purported oral promise in this hearing or in this document. Senior has promised to give us 1/3 of the estate. They didn't do that. Juanita's estate was fully settled by a district court when it entered the FSA. They're trying essentially at this point to unwind that district court's decision and relitigate the issues now with the hindsight of a purported oral promise, which they never brought up at the time. Res judicata would seem to dictate that plaintiffs are barred from bringing that claim now. Moving on to our third one, the statute of frauds. KSA 33106, no action shall be brought upon a contract for sale of lands or anything else.
You may finish. Go ahead.
Thank you, Your Honor. That is not brought in writing. Obviously, we have, as we've already discussed, a purported oral promise made 30 years ago, and then they entered into the FSA regarding the property. The FSA does not say that the plaintiffs will get 1/3 of Senior's estate when Senior dies. That would have been a promise to convey property at some time in the future that was not reduced to writing.
I'm sorry if my mind wandered for a second. Did you say that the oral promise preceded the FSA?
Yes, that is correct.
But then they didn't see fit to include it in the FSA.
Correct. It's nothing. There's no oral promise mentioned in the FSA. The district court made no note of an oral promise that was existing at the time.
And the son said, we didn't even read it because we trusted our dad.
Correct. However, there's Kansas case law that is not an excuse. You can't simply avail yourself by not reading a document and then say, well, I didn't understand the terms because I didn't read it.
The part that I keep on having trouble with. This is your father. I mean, this is your father. So I know Kansas case law is pretty hard. If you don't read it, you're responsible, but it's your dad. And I think that's a factor that bothers me of, well, you're out of luck. Because there's such an inherent trust we place on our family. But you may continue.
I understand your position, Your Honor. That being said, Kansas case law, as you said, is not soft on this issue. There's pretty explicit case law that father-son relationship does not create a pro se confidential relationship for this purpose. And it does not let you simply not read any document your father hands you and sign it without even checking the terms. They did, in fact, enter into a written agreement, and the written agreement itself said that they read it. They read it. So it's hard to now argue that, well, we didn't read it, but then they signed a document that says they read it. It doesn't quite come together, I guess.
So since your time is concluded, if you want to take a minute to just wrap up, that would be great.
Yes, thank you, Your Honor. Briefly, we believe that the court, in entering its judgment, which was rather short given the number of facts, number of days of testimony, lacked substantial competent evidence to support its finding in favor of plaintiff on the constructive fraud claim. We ask that this court enter a judgment in defendant's favor on the constructive fraud, or in the alternative, remand this to the trial court for additional findings of fact on the constructive fraud claim and on defendant's claims of affirmative defenses. Thank you.
Tell me, what's the size of the estate we're arguing about?
Your Honor, I would have to check the record at this point. I'm not entirely sure.
Could you give us a ballpoint estimate?
I believe it's in the several $1 million upwards range at this point.
Several $1 million?
Yes.
So several being 10 or several being 20?
I believe it's upwards of 10, I think less than 20, but I'm not certain at this point.
So in between 10 and $20 million.
I believe so, Your Honor.
That's the point I was trying to get earlier. My first question was, what acreage are we looking at? So thank you for your
Yes, it's a substantial amount of.
substantial.
Thank you.
Thank you, counsel, both for your arguments.